House Bill 1804 is a wrong approach for Oklahoma. It proposes to fix an immigration problem for the state that the state has no jurisdiction. It preempts federal regulation, sets a dangerous precedent for the state of Oklahoma. It raises constitutional and legal questions. This bill, if enacted, will create short-term and long-term social, economic, and political consequences that for this year, the centennial, will be a very, very dark beginning for the rest of the future of Oklahoma.
There's a couple of factors I'd like to point out. Number one, the Federal House of Representatives has introduced House Resolution 1645, which is called the Strive Act, which allows for fixing the immigration problem at the federal level where it needs to be fixed. This Strive Act, 1645, ostensibly has been cleared with the White House, coordinated with the Senate, and should be passed fairly quickly. The problem that House Bill 1804 attempts to deal with should be gone away. If it's not, if the House bill as it's currently under consideration in the Senate gets passed, there are a couple of things the Senate needs to keep in mind. Number one, they have provisions in there where county and city jails and multi-county jails have to retain prisoners who cannot produce documents that show that they are citizens. And they have to maintain them for at least 48 hours. And if they can't be bonded out, there's no provision for them getting rid of these folks. So they may have to retain them for an extended period of time, and there's no money provided in this bill for what is in effect a state unfunded mandate on local governments. The provisions in the bill as it is currently under consideration in the Senate needs to be really addressed and ought to be considered for economic impact analysis by the Oklahoma County Commissioners Association and by the Oklahoma Municipal League to make sure there's some recourse for local governments to deal with this question of unfunded mandate, except in addition to beyond just raising the local sales tax to cover expenses or raising the local property taxes to cover expenses, depending on whether it's a city or a county problem. So they need to reconsider this, and now is the time.
The points I want to bring out about the committee substitute bill on 1804, the first point I'd like to raise is that the words reasonable suspicion are used repeatedly throughout the bill. The vagueness and the subjectivity of that term has already been litigated in previous laws that have been passed in other states. On the screen you will see the case noted to substantiate that statement. There's a lot of things in the bill that are subjective, which is another reason why the courts have struck down laws regarding immigration, because they are broad, they are vague, they are subjective, and we're just asking that you use those valid reasons to discuss with your constituents why you would not want to pass a bill like that. And we're asking that you please review the material, this disc plus the paper that we will leave with you, so that you would have valid information to justify voting no for 1804.
I just wanted to add a few words. I'm not a person that has an analytical mind, but I feel that this whole process of this bill and the effects that it will have will be very divisive for the citizens of our state. I wonder, and I ask myself, what will happen to the children if their parents are picked up mistakenly? There's many judgments will be made upon just with the color of their skin, and they could be wrong judgments, and children will be left with their mom in jail or their dad not coming home from work that night. What kind of effect will this have on these children? This is something that I fear and I worry about.
I'd like to speak for a moment about how House Bill 1804 is preempted by federal law. There are two types of preemption. One is where Congress has specifically said that it preempts a field and that the state and local governments cannot regulate in that area. The other is where the the federal government has passed a series of regulations so extensive that it shows an intent on the part of the federal government to occupy the field to the exclusion of state and local regulations. Now, the second form of preemption will affect all of House Bill 1804. I think you'll find that in all of the cases that have been decided, the vast majority of cases have held that any form of state and local regulations of people relating to their national origin or status has been held to be preempted by federal law. Now, in particular, the provisions which relate to employment, governmental contractors, subcontractors, and especially this private cause of action, where someone can sue if they've been fired even for good cause, is preempted by federal law. The specific provision is Section 1324A of Title 8 of the U.S. Code, which specifically preempts any legislation on the subject by any state or local authority. One of the reasons people want to push bills like this is because they want to promote respect for law. But I think it shows very poor respect for law if the state government passes a bill that it knows to be unconstitutional.
Targeting immigrants at the state and local level does nothing to alter immigration patterns or the federal immigration system. Instead of lashing out unproductively and creating a bureaucratic nightmare for all residents, Oklahoma should engage in the national debate on how to address the immigration system effectively, taking advantage of skills and resources that immigrants offer, and promoting the health and safety of all residents. Please vote no on House Bill 1804.
Rushing to vote on a bad bill simply to be on record for voting against immigration is not the way to establish integrity with your constituents.